Begin with appearances once everyone's situated.
Your Honor, Glenn Carter on behalf of
Mr. Carter?
Your Honor, Joseph Thomas on behalf of Kent Crown Cortland.
Good morning, Mr. Thomas. So at the outset, a couple preliminary matters. I want to keep this very focused, and you can have a seat, Mr. Carter. Very focused today on just a couple discrete issues. I don't want to hear any argument about why the court cannot or should not award penalties against Lewis County. There is going to be a non-zero penalty assessed against Lewis County by the end of this hearing. I understand those arguments. They are preserved for the sake of appeal. Should there be one, we don't need to hear argument on that. I'm not going that direction today, so we don't need to spend any time with that. Also, I've received Mr. Cortland's objections to the court's ruling from earlier this week. I don't need to hear anything about that. I'll specifically note on the record the local rule regarding time for oral argument for contested motions can be waived by the court, as any local civil rule can be, and the court has implicitly and now explicitly waived that in accordance with the need for efficiency and the fact that the court was adequately briefed through the written materials on those motions. And I don't need to hear anything else about that matter. So all we're talking about today is penalties. There's going to be attorney's fees and costs, that there will be something later that we will have a discussion about that Mr. Cortland will have a motion regarding. Today, we're just going to talk about penalties. And specifically, I need to find something here. I don't want to hear argument about why everything that has been produced during the course of this litigation by Lewis County is the grounds for a penalty in this case. I went through prior proceedings transcripts to find specifically where this was discussed. It has been my understanding throughout this litigation that once the once the violation of the Public Records Act was established, that Lewis County would take an over-inclusive approach to producing documents, and we would then have a discussion regarding which documents that were produced were responsive to the public records request that would be supportive of a penalty in this case. Specifically, I'm going to read from the September 29th hearing regarding Mr. Carter's comments. It said, "Your Honor, we have tried mightily in the course of this case to collect all potentially responsive documents," et cetera, et cetera. "It is our understanding and our belief that we have produced all potentially responsive documents," et cetera, et cetera. "With respect to the burden clearly, the point that a company comes forward like we have, a government agency, and produces all these, they've been produced, they've had them for months. We presume at this point they go through them and they argue which ones were responsive and allegedly were withheld, and that's what the penalty hearing is about." That's what the penalty hearing is about. I am not going to be convinced that everything that was produced in the context that was just discussed was responsive to the original requests. I understand that there are arguments about that. I'm also not going to be hearing argument that it was somehow Lewis County's burden to show which ones were responsive and which ones were not, although Lewis County has made some effort to do that with its submitted briefing in this case. And so what I want to hear specifically is argument regarding the factors that go in determining a daily penalty rate. If there's any dispute about how many days we're talking about here, although I don't believe that there really is, and then how many documents we are talking about here. I know that Lewis County has not proposed a specific document number. They've listed a number of pages, but there hasn't been a penalty rate that's been proposed by Lewis County. I'm I've heard what the plaintiff believes the appropriate rate is. I have not heard from Lewis County. Zero is not an option. And so, and again, I can't force you to propose something. I understand that there are strategic considerations why one might not want to put forward a number to the court. I can't make you do that, but I find it helpful when that is done. So I'll leave that at that. And additionally, I didn't hear from Lewis County regarding what type of approach should be taken regarding what, how the counting should be done. I understand the plaintiff's position is that everything that's been produced, each page should be considered a separate record or document, and the maximum rate should be assessed for each day. It wasn't clear to the court whether or not Lewis County was disputing that, and whether or not they thought that certain pages were together taken as unitary records or documents, or if something like a subject matter or class or categorization of documents was the appropriate approach. That's not clear to the court at this point. And so I guess what I'd like to hear, the order of argument here would be walking through the factors first so we can set the rate, because I believe that that's going to be a significant issue today. Confirming what the number of days is, and then the number of documents. I like to go in that order. That's a lot of preliminary comments. Hopefully that crystallizes for you, Mr. Thomas, what I would like to hear from you at this time. And with that being said, I'm going to hear from you first, and I'm going to be doing 10 minutes aside. And Mr. Thomas, anything you don't use at this point will be saved for rebuttal, and if we need some more time, you can request more time at the end.
Your Honor, I'd like a ruling on each of the objections that were given to this court. We need to preserve the record for appeal, and we need a ruling of whether sustaining or overruling each of the objections.
So I don't believe that that is necessary for the record. I have an order that has been submitted, and there has been no motion for reconsideration, but to the extent you would like one, I am overruling or denying each of those objections.
Okay, thank you. Next, we file a motion for continuance because this is outside the scope of a PRA hearing according to the Washington State Supreme Court to determine which documents are responsive to a PRA hearing. If you look at Yusufian versus the Office of Ron Sims, and I'd like this on the record, it's 229P3D 735, at 743, and that's from the Washington State Supreme Court in 2010. It says, quote, determining a PRA penalty involves two steps. The first step is to determine the amount of days that the party was denied, and two, determine the amount appropriate per day penalty between $5 and $100 depending on the agency's actions. And while I know that the penalty has changed since then, the rest of the analysis still applies. That to determine the amount of records today is beyond the scope of today's hearing. We are not prepared for this. This court told us.
Okay, so here's what I'm going to do. I'm going to, at this hearing, determine the number of days and the penalty rate. And I'm going to allow the parties to submit briefing and not have oral argument on the records that we have are at issue here. I understand that there can be an argument that the differentiation here, given the nature of this case between the penalty phase and the violation phase, is unusual given that there was a blanket objection that we're talking about here. And so I am going to segregate that. I'm granting your request for a continuance with respect to that issue, given that you're objecting to that approach at this time. What we're going to do today is I want to hear argument, and I will rule upon the number of days we're talking about and the penalty rate that we're talking about. I will receive supplemental briefing that will be due. Next Friday's a holiday. I will not make you do anything on that day. By Monday, November 13th, both sides submit what they believe is the record that needs to be established and the arguments that need to be presented for this court to determine whether or not certain documents were responsive to the underlying PRA requests. In addition, at that point, I would like the plaintiff to submit his request for attorney's fees and costs. That will allow me, after receiving all of those materials, I'm sorry, so the 13th, both sides submit what they believe is the materials and argument regarding which documents are violations. We've had a lot of discussion throughout this case, a lot of briefing, a lot of argument. Both sides will get one shot at presenting their most compelling argument about that. On the 13th as well, the plaintiff will submit his attorney's fees bill and costs and any supporting argument or briefing to support that. On Friday, the 17th, both sides will be allowed to respond in writing to the other side's argument and briefing regarding what documents constitute responsive documents that violated the PRA by not being provided. And Lewis County will have an opportunity to respond to the request for attorney's fees and costs. A reply, if any, as to the fee issue only may be, and then cost issue, may be filed on November 21st. Bless you. We won't have any more hearings. We're going to have those materials submitted to the court. Once that is fully submitted as of November 21st, I will then consider those matters and issue an order at that time. Any clarification regarding that?
Yes, Your Honor. Would you like the documents included in our briefs?
So I don't need the documents included. If you believe that there is something, that there is a dispute that requires my consideration of the four corners of a document, that is your discretion and judgment to attach that. I don't want 3,600 or whatever it is pages of documents in my chambers, and based on, if it were necessary, I would welcome that. Based on my review of what I'm aware of so far, I don't think that that is necessary. I believe, based on what I've seen so far, that categories and descriptions of documents are not really in dispute, and that would be sufficient for the court to determine whether or not a document was responsive. So it's a non-answer to your question. You can't even think I need it. I don't think I need it at this point, but you are representing your client's interests to the best of your ability. And if you believe that I need to see it to resolve some dispute, you are welcome to submit it. But again, I think it's unlikely that I will need to see it. A description is likely sufficient. So I've eaten a bunch of your time, and I've granted your request for a continuance as to those issues. I still want to move forward with the, let's do the reverse now. Number of days. How many days is it again?
Your Honor, we would submit 586 because that's when the documents were produced, regardless of how many documents were produced on July 24th.
Thank you. And then you are requesting a penalty rate of $100 per day per document. And the factors that the court considers have been determined by our Supreme Court in some detail. And so if we could have argument regarding what you believe supports your request for a $100 rate.
Sure. Thank you, Your Honor. First, let me go over Lewis County's arguments because they're a little unclear. First of all, our Supreme Court was very clear and they enumerated aggravators and mitigators for this court to consider as a framework for consistency across the state. Lewis County rejected even categorizing their aggravators or mitigators arguments under any of the Supreme Court's enumerated list of aggravators and enumerators. Since Lewis County rejected the multi-framework approach that the Yusufian court proposed for courts in order to follow, their arguments should be disregarded because we don't know how to apply them within the multi-factor approach. But even if you want to try to apply them, let me go ahead and try to explain why their arguments should not be persuasive to this court. Their first mitigator is GR 31.1 was reasonable or asserted in good faith. GR 31.1 is a sham defense, plain and simple. First of all, there's 5 reasons for this. First, GR 31.1 was not even effective at the time of Mr. Cortland's request. Mr. Cortland's request was made on December 9th, 2015. GR 31.1 didn't come into effect until January 1st, 2016. It's dishonest for Lewis County to say that they were relying upon a court rule that was not even effective. Second, GR 31.1 never applied to the documents in question. Mr. Cortland's request had to be for documents that were already created. GR 31.10 states that GR 31.1 applies to documents created after the effective date, which would be documents created after January 1st, 2016. So none of the documents that Mr. Cortland requested that were already in existence on December 9th, 2015 would have applied. Third, GR 31.1 does not apply to county law libraries as this court ruled on April 21st and in its amended written order on the merits under GR 31.1 K1. Fourth, when there's a conflict, the PRA governs, and that's under RCW 4256.030, and that's been ignored too. None of this was in their analysis. The fifth reason is when substantive law and procedural court rules conflict on a substantive issue, substantive law prevails. The Public Records Act is substantive law, and GR 31.1 is merely procedural. That's at our opening brief on pages 23 to 24. So there's no basis to claim GR 31.1. That is not a reasonable mitigator. That's not a reasonable defense in this. That should not be taken into consideration. Second of all, there's no training or supervision. Lewis County claims as the mitigator that there's no training or supervision that would have informed the Lewis County Superior Court that the Law Library Board is not a judicial agency. Well, first, the Lewis County Superior Court is not trained in the Public Records Act, and that's why a public records officer pursuant to 4256.580 should have reviewed the request for compliance under the Public Records Act. Lewis County, as this court articulated, Lewis County is the one that violated the law. As Lewis County does throughout its aggravators and mitigators, it asserts non-party fault in this kind of mass argument. So here they're saying, well, the Superior Court acted reasonably, but that's non-party fault. We're talking about what Lewis County did here, and Lewis County did nothing. Lewis County referred it, like this court ruled as a matter of fact, that the county clerk referred it to the Superior Court, and Lewis County didn't even respond under the Public Records Act. So Lewis County refused any training or supervision. Mr. Cortland's request was clear. Mr. Cortland's request was labeled as a public records request. Even Mr. Carter's response on December 11, 2015 recognizes that his request was made under the Public Records Act. There is no reason to confuse this for a judicial request. This was made under the Public Records Act, and Lewis County intentionally and knowingly tried to subvert the Public Records Act and conceal records by going to the Superior Court and using a more narrow or restricted rule in order to hide documents that could be potentially embarrassing to the county. The third mitigator is, and so another argument of that is the Superior Court is not a party to this action. The third mitigator that Lewis County uses is this is not a case where the request was made under the Public Records Act. This is a lie. This case was made under the Public Records Act. The caption was made under the Public Records Act. Mr. Carter's request on December 9th says that the request was made under the Public Records Act. However, they chose to review them under GR 31.1. This is a blatant lie, and it's making a mockery of this court. Mr. Cortland had the statutory right to make them under the Public Records Act, even if there were an option to make it under the GR 31.1. There's nothing prohibiting Mr. Cortland from making it under the Public Records Act. So they start with these aggravating factors, and again, they don't list what aggravating factors they're talking about, but they say that judicial status was used in good faith. Arguments in favor of judicial status were substantial. First of all, judicial status was used in bad faith, and it's still being used in bad faith when Lewis County refuses to even recognize that Mr. Cortland's requests were made under the Public Records Act. This is a Public Records Act case, Your Honor. We've been talking about this for a year, and Lewis County still refuses to even acknowledge that this is a Public Records Act case. This is how far the bad faith goes in this case. Second of all, Lewis County didn't even simply respond on the Public Records Act pursuant to RCW 4256-520. That's all they needed to do. They needed to send a 5-day letter to start things out with, and they didn't. The clerk referred it to the public records officer. It clearly was identified as a public records request. That simple step wasn't even done. I want to refer my arguments as GR 31.1 is a sham defense. Under this argument, Lewis County also argues as an aggravator that the court already ruled that the Lewis County Superior Court was non-intentionally compliant. Again, this is arguably non-party fault. We're not talking about the Superior Court here. We're talking about Lewis County's actions and why Lewis County should be culpable. Lewis County did not argue non-party fault in its answer. This is a violation of the Washington State's pleading notice. Any argument about non-party fault should be thrown out the door, and this is the basis of every single one of the aggravators or mitigators, in this case, argued by Lewis County. Lewis County submits as another aggravating factor that the Lewis County Superior Court terminated the Law Library Board because of efficiency. It doesn't matter why they terminated the Law Library Board. The issue is, why didn't they produce the records under the Public Records Act? Again, this is talking about non-party fault and confusing the issue. Another aggravating factor that the Lewis County lists is they said deterrence does not apply in this case because the Superior Court was reasonably responded. Lewis County's known about judicial records since 1986, since the Nast versus Michael case, which is 107 WN 2D 300 in the year 1986, that the judiciary is not subject to the Public Records Act. His Public Records Act request was labeled under the Public Records Act. All they needed to do was analyze it under the Public Records Act, and we would be having a completely different discussion today if they cited some sort of exemption under the Public Records Act. However, no steps were taken whatsoever under the Public Records Act. So let me go through real quick the aggravators and the mitigators that the plaintiff argued, that Mr. Cortland argued, because these are unopposed and this should go by very quickly.
You have 3 minutes left.
The first mitigating factor is the lack of clarity in the Public Records Act request was never an issue as an affirmative defense in this lawsuit. That's unopposed. The second aggravator is listed by the Yusufian Court is the agency's response or legitimate follow-up for clarification.
I'm sorry, could you slow down a little bit? The Yusufian Court is the agency's response.
Right.
Okay.
So the second mitigating factor in Yusufian, the agency's prompt response or legitimate follow-up for clarification, that never happened. That's unopposed. Mr. Carter recognized that it was made under the Public Records Act, but they never followed up under the Public Records Act. The third mitigating factor is the agency's good faith, honest, timely, and strict compliance with the Public Records Act. There was no compliance with the Public Records Act because they tried to convert it into a GR 31.1 request. The fourth mitigating factor, the proper training or supervision with all procedural requirements. Again, this is unopposed because there were no procedural requirements. Mr. Carter even admitted in the interrogatories that he is trained under the Public Records Act. However, Mr. Carter didn't even respond under the Public Records Act. He didn't refer to a public records officer. There is no training or supervision that occurred here. There was the entire system failed Mr. Cortland. The fifth mitigating factor, the reasonableness of an explanation for noncompliance by the agency. I addressed this already under GR 31.1. GR 31.1 is a sham defense, and that's what they listed in Mr. Carter's December 11, 2015 response to Mr. Cortland. The sixth mitigating factor, the helpfulness of the agency to the requester. That's a non-issue because they didn't even respond to the Public Records Act. And again, Mr. Carter stated in his response brief that Mr. Cortland didn't even make a Public Records Act request. This is the height of disingenuousness for them to even claim that this mitigating factor would even occur. The seventh mitigating factor, the existence of an agency system to track or receive public records. This wasn't an issue because they never treated it as a public records request. We don't even know if there was an agency system. And so not one of the mitigating factors applies. I'll save any time that I have left to talk about the aggravators after.
Thank you. How many days, Mr. Carter?
the documents are split into two groups. The first group, which was up to base number 1852, was produced on June 9th, which is 548 days. Of the 214 pages that we identified as responsive, 206 were delivered to the other side as of June 9th. So those will be subject to 548 days. Only 8 of the pages were delivered for the first time as of July 24th. And that would be subject to the 586. Yes. Your Honor, there are two kinds of documents that were produced that we deem to be responsive. And those two deal with two of the requests. Actually, there are 3 requests, but you recall that the last 2 of those requests are related: district court filing fees and superior court filing fees. Those should be treated as one basic kind of document, which is responsive to both. The same document is responsive. And that's called the revenue report with respect to the filing fees which we provided. Those are 14 pages total. The others are the expense reports, which are the expenditure reports. And that's the only other type of document that has been, that we deem to be responsive. And the expenditure reports constitute 206 pages. Those expenditure reports are just of 2 types. One is a cumulative annual report and one is a monthly report. But they are the same report. It's the same document, just based on different time periods. We would submit that there are only 2 kinds of documents, 2 documents. The one being the revenue report, the other being the expenditure report. We would submit the total pages, 214. 206 associated with the expense reports and 8 associated with the revenue reports.
So that's the type of thing that I could envision wanting to see in the supplemental briefing, the actual expense reports. If it's really the same report over and over again, that would be material to my decision in that regard.
It would be, right. And we would provide that to you.
Are you going to give me a number for the penalty?
Your Honor, you know, what I would say, look, you know, I would say that, and it's part of my argument on litigation and aggravation, it should be towards the nominal end. It should be in the $5 to $10 range. And the reason for that, I know how Mr. Thomas feels about this and the zealousness with which he states his argument. But Your Honor, the issue that was before us back in December of 2015, the issue is, are these subject to NAST? That's the issue. It's not GR 31.1, as you keep saying, that's related. But the issue was when that request came in to the clerk of the Superior Court, she forwarded it to the Superior Court asked for my assistance. The question is this subject to NAST? Are these judicial documents? That's not truly an exemption argument. It's truly just the scope of the PRA.
You don't even get to an exemption log. In that situation, you don't need to respond.
No, but we did respond. We did respond. I suppose technically, and actually Judge Murphy asked why. Why did you respond? But we did respond out of a desire to make it clear to Mr. Cortland that Mr. Thomas doesn't believe me and he thinks I'm the most evil person in the world.
Objection.
But the argument is that we believed at that time that GR 31.1 would provide a, up to that time, unavailable way in which to provide judicial administrative records. At that time, as you'll recall, GR 31 was the only way to provide records that are court records. We thought there was a substantive issue as to whether these were judicial administrative records. They were the records of the court in the administration of the law library. I know that your ruling is that that isn't a fundamental function of the judiciary. But that was a very real issue at that time. And so we looked at it. We thought that these were judicial records and therefore not subject to the scope of the PRA. Obviously, it wasn't that we were just we don't care about the PRA. That wasn't our approach. Our approach was at that time that we felt these were within the judicial exception to the scope of the PRA, and that's the position we took. The response is not a blow-it-off response. The response is long. It states what the nature of the requests are. It asks, it says what we understood the request to be for the records of that management and administration are records of a judicial agency. I understand you to be requesting those records, the records of the judicial administration of the law library. If your request is not for those records, please let me know. And then we provided the response, and we said we would provide them under 31.1. The second that this court ruled that we had to provide those records, we made every effort to do so promptly, and we believe we did so promptly and fully. The intention at the time was that if you had made the request under 31.1, that yes, we would respond to it and provide records pursuant to 31.1, regardless of what the terms are technically of 31.1. That isn't the point. But anyway.
So I have one question for you at this point. I understand your argument. It's been clear. The only factor that I believe there's some room for debate as to in these circumstances, the last of the aggravating factors, a penalty amount necessary to deter future misconduct by the agency. My question to you is, I don't know if you've received additional public records requests towards the Law Library Board. If you have, how has Lewis County responded, or how would you respond? Would you be taking the same tact in the future at this point, pending any possibility of a reversal by a higher court of this court's currently binding ruling?
Your Honor, you have that case. What we did with respect to the subsequent requests that were made by Mr. Cortland in September of 2016 and October is that we went ahead and provided the documents.
And that was my understanding, but for the purpose of making sure this record is clear here, at this point, unless and until that order is reversed or somehow mooted, you are responding to public records requests as they would come in.
Your Honor, that's correct.
Okay.
Your Honor, I don't think any of these other factors apply in terms of the aggravating factors because, again, it's not a lack of training or supervision, it's a lack of guidance in the law. We made a choice. I made the wrong choice, according to your ruling. But it was a good faith choice. It wasn't negligent, I don't think. And of course, to show bad faith is at least negligence, according to the standards. And it was a wrong choice based on, with all due respect, your ruling. And so I deferred to that ruling. But at the time, we were acting in good faith. And if the request had been made under 31.1, we would have provided it. There is, I submit again, I don't think that the county is culpable in these circumstances. I know, be real quick. The two purposes are produce the records. We produced immediately when you said so, and we produce it now regardless, pursuant to the request we received. But the other part is to deter misconduct. And as I say, the court now provides those documents. And as to the county, and you understand my argument, I don't need to restate it, but the county hasn't done it. And so, Your Honor, is there anything else I can add?
That's it.
Thank you.
Thank you, Mr. Carter. Brief last word, Mr. Thomas.
Your Honor, I think your question to Mr. Carter hits the crux of the issue. Is there any effective deterrence with this lawsuit? I want to draw the court's attention to page 8 of Lewis County's response brief again that says this was not a request made under the Public Records Act. Mr. Carter came up here and said the court now provides these documents. The Lewis County is still allowing the court to answer these requests that this court ruled are public records and are allowing the court to handle these requests. That is not proper under a long string of case law because the judiciary is not subject to the Public Records Act. That is a well-established case law that we argued at the merits hearing. And for the court to go ahead and respond to these records would mean that the court would be an agency subject to the Public Records Act. And so unless this court wants to nullify 30 years of stare decisis and precedent that the judiciary is not an agency subject to the Public Records Act, this court needs to find Mr. Carter's arguments not persuasive today. Because the judiciary cannot supply the documents, it needs to go through a public records officer, it needs to go through the county. That's clear law under RCW 4256-580 that states that the public records officer ensures the compliance with the Public Records Act. And so, again, Mr. Carter came up here and he's arguing non-party fault by saying that the Lewis County Superior Court is ensuring the compliance with the Public Records Act, and that's not what the Public Records Act is for, because the judiciary is not subject to the Public Records Act. Mr. Cortland cannot sue the judiciary for any problems with the Public Records Act. He can only sue the county because the county is an agency. So this court needs to look at non-party fault. Lewis County is not being deterred. Even in their response brief, it's evidence that they are still thumbing their nose at this court's opinion on April 21st and is reduced into writing on August 2nd, 2017. Thank you.
Thank you. I'm not going to rule at this time regarding the penalty amount, the rate. I'm going to issue a written order/ruling once I have everything that will completely dispose and resolve all outstanding issues in this case in a unified manner. The parties have guidance regarding when different materials are due to this court. Shortly thereafter, around Thanksgiving time, I will be working on finalizing those matters so that everyone has the relief and the clarity and the rulings that they're entitled to in this case, and then we will go from there. Do the parties require any clarification regarding that?
No, Your Honor.
No, Your Honor.
Thank you very much. Have a good weekend.